Hello and welcome. My name is Marc Blatstein, the physician founder of Physician Pre-Sentence Report Service. Welcome. This video is going to be on the importance of hiring the right attorney for you. And of course, we're on federal criminal defense. It can be on federal crimes, but quite frankly, if you're facing any sort of a criminal or legal matter, I would imagine it applies there too. So let's get started. You may have heard rumors or received a target letter. Target letter is definitely not a letter anybody wants to get. And rumors, it happened to me. I had patients come into my practice and tell me that the FBI was asking questions if I ever performed surgery on them, and they said yes, and met them and showed them their scars. And so it did happen to me. And if it's happened to you, it's going to happen to others also. 2006, for transparency, I was convicted of a felony, and I panicked the entire way through. I was not the greatest client. And after I was grateful enough with hard work, I did get my medical license back in 2010 and decided to transition after that into working with all of you because knowledge and preparation got me through education and practice successfully until this event. And my goal is to work with all of you to prepare you as you transition into this world that you've never been into before. So if you've heard rumors, if you've heard two, then figure that the Department of Justice already has their case 90+% complete. So if you want to know when to get started, and if you've talked to attorneys and then they say wait, or if you've talked to friends, they say wait, well, get new friends, get new an attorney, start yesterday. And getting a new attorney takes it's just not a referral. It's someone you have to ask questions of. And I did everything wrong. And the reason I made this transition is to show you what I've done wrong. So hopefully you don't repeat my errors. But there's questions you need to ask, and don't be shy. I've had surgeries, I've had patients come into me. They say, well, can I call a couple of patients of yours to see if they were happy? I said, fine. Before I had hip replacement, I wanted to speak to other patients to see, how they did. And so, if HIPAA comes up where that has to deal with, these are personal records of the individual, great. I mean, the attorney's correct. But what they can do is that they can either take a black magic marker and black out everything's personal, or with Adobe PDFs, there's actually an area where they can just click on redact and they can black out automatically. If you happen to be unlucky enough to be on pretrial supervision or pretrial detention, if you're on pretrial supervision and you're home, maybe with an ankle bracelet, don't do anything wrong. Whatever the judge tells you to do it. You're not President Donald Trump, where you can do whatever you want and still stay free. Everyone else is going to wind up kind of like Sam Bankman-Fried and wind up being thrown into jail, or in his case, a detention center in New York. So, there are strings attached with everything you do, and everyone is watching. In detention, you're also there, but you have no freedom, but you may be waiting years. And I don't know if you've hired an attorney or you haven't hired an attorney, but either way, this is time to make good decisions, and you've got a lot of time to do it. The thing is, you don't know where to start. And this is where I'm trying to step in. I'm sure that there's others and there's books where you could read and get good advice. This is just from what I've learned. And one of the things is that you can request a speedy trial. Don't request it because I'm telling you, but you need to have an attorney because you don't want to be sitting around, especially on supervised release pre-trial at home, because it doesn't count towards any time while you're in prison. We're going to go to the next slide. Get that correct. There we go. And so when you start talking to attorneys and interviewing them, you want to know, why did they go into law? Just ask them, why did you go to law school? Some might have really interesting reasons, but you're trying to humanize them and just kind of get everybody on the same plane. Then after law school, did they go into private practice directly? Why? How many active cases do they have? If they became a federal defender, they probably know a lot about federal criminal court. Did they move into private practice? And what was the reason? Probably to make more money, which is okay. Again, how active is how many cases do they have now? How active is it? Because if they have a lot of cases, and if it's a large practice, if it's a small practice, then how much time will the attorney have for you? If it's a large practice, then who are you going to be dealing with? The attorney or paralegals, but we'll go into that. If they're a prosecutor, we'll cause them to move into private practice. And then looking back, would they have done anything different? What kind of cases do they remember that was interesting? What was the most interesting case that they had? Why did they move to private practice? Most of them, they may not say it, but they wanted to go into private practice to make more money. Well, that's okay. Be proud of it. They've done their work all along. They've been to law school. They have big bills for school and tuition. For each of these attorneys, what percentage of cases have they have that are similar or exactly like yours? And as you're talking to them, if they, as you're becoming more comfortable, because what you're doing is having a dialogue with them, just remember that no attorney, no consultant, nobody can guarantee anything. No one can promise you that they know the judge. They can get you out of prison early. That the first step back is a guarantee. If they do, then have them just nicely ask. If they're quoting something, ask them to show you the quote. If they're showing you the law, because it just is not the case. The Bureau of Prisons can do anything on any given day, and they do. The first step back was started in 2018. They still really have not gotten around to calculating earned time credits multi-years later. A judge on any given day can get out of the wrong side of the bed and heaven help you. So nobody can guarantee anything. And I never did. You go, if you ever had surgery, you're never going to have a surgeon tell you, I'm going to guarantee you the result. If they do, find somebody else. They're crazy. You want to speak with a couple of clients. I mean, nobody's going to be happy. The Department of Justice has a 98% conviction rate. That's pretty big. And so, but still, there may be several families that will be okay with talking to you. I mean, maybe they got a lesser sentence. They still had to go to prison, but they, were comfortable or more than comfortable with how the attorney, their empathy that they showed. Sentencing memorandum. Sentencing memorandums is a document that's multi-page, filled out by the attorney, sent into the judge a little over a week before your sentencing hearing. This is where they spell out certain factors and points of interest that will help the judge in mitigating or lessening your sentence. It's not where they teach the judge. It's where they specifically point out factors about you and then cite the laws that will be particular to you in that reasoning. But it's not where they're going ahead and quoting different statutes, like Booker type statutes, which you may not know, but to teach the judge something, because judges hate that. So the purpose of seeing several sentencing memorandum where they have blacked out or redacted on Adobe files all personal information so that you're not seeing any personal information, you can see if all the memorandums look similar, continue talking to other attorneys, then find out how full is the current caseload. Will you be interacting with paralegals, other attorneys, or this attorney? Ask them what their thought is. If you're going into this and you really feel that you are innocent, you are 100% innocent, you want to go to trial, ask the attorney for a case like yours, have they had other cases like yours go to trial, and what percentage or how many have they gone to trial with and how many have they won? And what's their percentage of winning in any trial case? And lastly, on appeal, what's their percentage have they won? It's pretty likely, it's pretty low. There are those that win, there's no doubt, and yours may win. And if you feel strong, go to trial. What you don't want to do is aggravate the judge or prosecutor. And so always stay polite as you can. And should you lose, and even if it goes to an appeal, you still can go through the exercise. You still can understand that if you're a business, for example, and there were people hurt, you still could, as owner of the business, people were hurt. You can accept the fact that they were victims, and you feel, have remorse that they were victims to whatever occurred. You need to get into that frame of mind in order to get prepared for the next phase. Ultimately, would be sentencing, or before that, the pre-sentence interview. This is called the narrative, which is your story as opposed to the indictment. I'll go into that later, and there's whole YouTubes or videos on that. But you don't want to aggravate everybody ahead of time, so everything is done with just being polite and very conservative, if you will, the entire time. Never challenging the court. Mitigation. So you've heard rumors. You found your attorney. When do you start? When can I start defending myself, mitigating everything? Lessening the act of lessening the sentence. Well, they may say, wait. Let's start discovery first. Whether you're going to trial or you want to plead guilty, first off, if you know you're guilty, there's no discovery, because you and your attorney should jump on that right away. It'll save you legal bills with your lawyer. It'll save the prosecutor from preparing for trial, and it should lessen any type of sentence. Plus, is your attorney familiar, hopefully, with the personal narrative, possibly with the release plan? And definitely they know the allocution. But they should take the time with all three of those with you. Now, they don't have the bandwidth or the time for themselves or the staff to help you with your narrative. This is where you either do it yourself, you find someone to work with, myself or anyone else, because it has to be your story. Because judges know the crimes did not happen in a vacuum. Judges want to understand who you are, why you did what you did, understand the effects from childhood that brought you to the point today to where you broke the law, you're standing in front of them, and they want to understand that that you have accepted responsibility, you have created victims, you have remorse for the pain and harm that you have done to them, and that that you have to make things right first for the victims. And then the judge wants to know that they don't want to see you back in the courtroom again, and that entails some sort of release plan. And so the release plan, while it seems premature at this point, and again, I have a page on my website that goes into that a little bit more in depth, and it is premature, but it's something to be thinking about, because it has, in my mind, 4 stages. One stage is where it's written out very briefly, and it mirrors your personal narrative, which is your whole story. And that can be 20 pages. It can be more, it can be less. And it's rewritten a dozen times possibly. And it can also be a short video, 10 minutes or less. There's going to be a stage where it's before your pre-sentence interview. It's a stage before your allocution, which is your day of sentencing with the judge. Then it's before you, it's while you're in prison. And then the fourth is right before you leave, like a year or two, year and a half. And so criminal defense attorneys, this is Judge Robert Scalia, and this is the link to it. If I put this up over it, it should come up. There it goes. Alan Ellis, the attorney, he interviewed the federal lawyer, September 2017, where his defense attorneys should emulate their death penalty colleagues by starting for preparing for sentencing as soon as possible. So you want to find out from the attorney, how important are these? How soon should you begin writing your story, which is your autobiography? And that is your personal narrative. And so my feeling is that you have the Department of Justice has publicly released your indictment worldwide through the press. Apple has theirs, has their story or icon, which is the Apple. Tesla has SpaceX. Everything that we've talked about should be included and prepared for you, and you're prepared before your pre-sentence report. For example, if they say that this should be done for your pre-sentence report, Marc Bennett, federal judge Marc Bennett, has been quoted in a YouTube interview, it's on my website, is saying that he'd be very interested in seeing that. In other words, before you get to your pre-sentence interview, the pre-sentence interview is at minimum 3 months before sentencing, at minimum, is when the probation officer gathers all the information about you. You've provided them 1 to 2 weeks before your interview, your biographical background, which includes a comprehensive medical file if you need it, personal identification information, everything, all that you can find on the website. It's your highest level of education that you've been, copies of everything, military background, et cetera, driver's license, your financial background, everything, plus your personal narrative, your release plan. And all of that is proofread, organized, and then provided through your attorney to the probation officer a week or so before the interview, because that gives the officer a lot. For us, it shows the probation officer that you respect their time. They have no time, so that they have the time to read everything and enter all your information into their probation report when they're not being rushed. Then on the day of the interview, in a more relaxed environment, they get to meet you, ask you any other questions they may have, and they leave the interview with a better feeling of who you are. They then go ahead and they do their investigation, write up the official pre-sentence report. You proofread it, and proofread it you must, and then they send that off to the judge with your sentencing recommendation and hopefully a few kind words. This may prompt the judge to have a discussion with you, and that is your allocution. Going on, you want to talk to your attorney. Ask them how they determine their fees, flat or hourly. If it's a retainer, does it stay current, or when it's used up, do you have to do more funds? How does that work? What does he think it's going to cost? I mean, if it's too low or too cheap, I mean, it may just be that. So if you're interviewing several attorneys, you'll be able to get a feel for, what the price line is in the area, but it can be in the hundreds to thousands of dollars per hour for a flat fee. Sentencing memorandum that I've touched on earlier, judges think it's critical, and they do not think much of attorneys who do not provide it. And speaking to your attorney, you want to know. I mean, especially when you ask them how many cases do they currently have, who are you going to be communicating with? Is there going to be paralegals or other attorneys that are working for them, email, phone, or both? And, do you have a retainer there? I had to keep a retainer. When my retainer was used up, I had to add more to it. But the retainer, I think, started at 1,500 and then jumped to 50,000. So it wasn't cheap. Those are only the starting numbers. Lastly, it's helpful if the lawyers have just access to information regarding what is life like inside what's life like inside federal prison. In other words, do they have interaction with people like myself? All right, I had a federal 2006. I had a felony conviction. In 2010, I was grateful to have my medical license reinstated. But it's important. I think it's important to know what to expect when you go into prison. I didn't know what to expect at all, and you'll get that from my video. Do they have a sentencing mitigation expert with BOP prison experience? It's important. Check with the state bar for any potential discipline issues. You may think that this is not necessary, but I have a client that he had an ongoing federal court case, and eventually he had to drop his attorney 2 weeks before he went into prison. Came to me, and it turned out I Googled the guy, and he was a personal injury lawyer. That's crazy. And I was still able to do as much as I could for him. He was I believe, in and out of prison, and he went in for His sentence was 3 years. I think he was in and out within 5 to 10 months, something like that. Being prepared is critical for your welfare. Through my story, the video is going to explain just why finding the right attorney for you is important. Preparation and knowledge was and is my reason from transitioning from patient care, because the Department of Justice comes at you with an infinite deep pockets financially to make sure that they put you in prison. They have a 98% conviction rate. And so everything you do from the day that you learn they're knocking at your door or before is important to your freedom. And now we'll see. This is why I tag preparation is critical as well as knowledge, as both will reduce you and your family's fears. This fear is mostly fear of the unknown. How is by asking questions to your attorney, who you want to know is really defending you. The more you know, the more you and your family will have confidence and comfort. What can you do? I recommend narrative, release, plan, and allocution. The narrative is going to take, it's a painful right. I mean, I didn't know about it, and 10 years later, I wrote it, but it's a painful right. Prepare and understand what you're getting into in the federal prison. Go online and look at the BOP website. There's a financial responsibility program. If you're going to go into the First Step Act programs to try and get out a year early, you take, first of all, it's approximately 2 years of earned time credits will get you 1 year out early. But if you have a financial penalty, then you have to participate by making payments monthly. I believe it's monthly or quarterly. I forget. Into their program. Good time credits is 54 days a year. And you can get all of that. I believe they donate that to you up front, but you can lose it very easily. You can lose all of it. The drug program, which I didn't put on here, is a year off your sentence. And that can be for legal or illegal drugs. It can be for over-the-counter medications, prescription medications, illegal drugs. It can be for gambling. It could be for therapy, sex crime. But possibly, if you have all this pretrial release time at home, or even if you don't, maybe you start Alcoholics Anonymous, Narcotics Anonymous, Gamblers Anonymous. These programs, you get a job if you're the CEO of a bank or a big corporation. Deliver pizza. The judge will like to see. They like seeing that. They don't want to see that you stayed home and do nothing. I mean, for me, I had to take all the time I had and begin to break down my practice, refer patients out, and then close my doors. The next slide is my story, is my video. It's beyond the attorney interview. And I wasn't the best client. I hope you consider my recommendations, and I will touch base with you if this works correctly.
Hello and welcome. My name is Marc Blatstein, the physician and founder of Physician Pre-Sentence Report Service. Let's see if I can get this a little better. Okay. So if you're facing indictment, sentencing, or you feel you're the target of an investigation, I hope you listen to this through to the end. For transparency, I too was convicted of a felony about 2 decades ago, a little under 20 years ago. There was never any issue regarding the quality of patient care, and I was grateful back in 2010 to have my license reinstated in full. But at sentencing, the judge did say that he did not want to see me back in my courtroom. And I thought that because I had an attorney that was a former prosecutor, that they're the best of the best. And so I guess I didn't do my due diligence. I don't know. I'm sure he was trying the best he could, but I don't know that translates to an excellent white collar attorney. And so, of course, we then next asked if we could do it, appeal the indictment, not the sentence. And we were clear on that. And the judge said we could. But I was also the deer in headlights. I was pretty panicky the whole time, so I was not a great participant. And you really need to participate with your attorney through your entire defense to get the best outcome. And so a lot of what I'm going to go through is going to be preparation. Preparation is going to be what caused me to eventually transition from patient care into working with those of you who are justice impacted and essentially facing the Federal Bureau of Prisons. But at the time, I was unprepared for a litany of things. First, when I went to a federal prison camp, and this was a freestanding camp. And even with that, I did not know what to expect. When I went there, it was very limited fencing. The staff secretary came out, brought me inside, and all of the other inmates that were working their way down from higher security places told me that, this was Club Disneyland. I didn't know anything. I left there, went to the appeal. By the time we were barely done making the appeal, the judge's gavel hit the desk and appeal denied. He told me I had to go back to prison, and I almost fell through the floor. I didn't know that was an outcome. And I knew nothing about a narrative or release plan. I knew nothing about what to expect from federal prison. But now I was on my way back to a satellite prison camp. So what's the difference? Well, the satellite prison camp is adjacent to a medium security prison. This one was. The other one was freestanding. And so now I had to go, and all of a sudden I'm looking at guard towers, people that are shackled and handcuffed, and razor wire, and I went in and I went through the screening process, and then they told me that you were going to put you in solitary confinement. You could be there for up to a month. We don't have any of your paperwork, and the door clanged shut. And like I'm getting claustrophobia, and I'm going, I don't get it. And so all of this was adding to my list of what I was unexpected and unprepared for. And so I proceeded to, constantly ask the guards if I could leave this solitary confinement to go to the bathroom, to go get a drink of water. Eventually, psychologist, psychiatrist, doctor, I don't know what the woman was, came down, took me out of solitary confinement, stuck me into a small office, and eventually came in to talk to me. Crazy white boy. And she wanted to know if I was suicidal. And I looked at her and I told her no. And she wanted to know if I was anxious. And I said, definitely. And she wanted to know why. And I told her because I was in a federal prison earlier. I did my time. I got out. I had an appeal. I lost. I was denied. I was told I had to come back here. I arrived when I was supposed to. I came in. All the judge's orders, the commitment orders, the pre-sentence report is driving down the road because I self-surrendered. I'm not allowed to call the car to have it come back with the orders. And I'm going to have to sit in solitary confinement for up to a month. I said, I just can't do that. And so she told me to sit still. And I don't know how long it was. I'm sure it wasn't a long time, but for me, it seemed like forever. And eventually they had someone escort me up to the satellite camp. But the moral of the story is I was unprepared. And it's only years later that I learned that if you're going to a satellite camp, this is what can happen. And so it's very important that being prepared is critical for someone. Everyone handles prison differently, but for me, being prepared would have made a big difference. And so this was a significant reason that caused me to have a career change. And so part of my mission is wanting you to be prepared, but is also I want to earn your trust. And in earning your trust, I also want you to understand that you also need to participate because this will take both of us. You also will need to get an attorney who, in addition to being a criminal defense attorney federally, also needs to have experience practicing in federal court with crimes similar to what you're facing. You're going to need to feel comfortable with this individual and follow their recommendations. When they ask you to do something, there's a reason you should do it. As I said, you want to have experience in cases similar to yours. All of this stuff is available on my website through YouTube's. No attorney and what I do is say is help mitigate the sentence or help with sentencing placement into a BOP facility. When you get an indictment, the feds have 98% of the people who are indicted or people that think that the feds are snooping around after them wind up going to prison. So I help mitigate that. And so at the end of the day, no one can promise what's going to happen. When I ever did a surgery, I can't promise a patient what's going to happen at the outcome. Well, I like to think I know mostly what can expect, but nobody can promise. Nobody can tell you what the judge or the Bureau of Prisons can do at the very end. They can't. It doesn't happen. And so the earliest that you become aware that the Department of Justice is something's beginning to happen, the earliest you begin to prepare, the better. But at any point in the process, it's better to start rather than not starting at all. You don't want to be an ostrich having your head in the sand because your tail is going to be out there blowing in the wind, and that's not good at all. As soon as you know, if your crime is involving some sort of substance abuse or a sexual issue, and the instant you know, and where you know that they're sniffing around an indictment, you get a target letter, however you know, you want to enroll either in Alcoholics Anonymous, Gamblers Anonymous, Narcotics Anonymous. If it's a sex crime, maybe do some sort of all-night sex therapy. If you can afford it, an in-person therapy type program. If you have with your attorney, they may think that you need some sort of forensic psychology evaluation. Whatever the attorney feels you should do. If there's some sort of restitution involved, begin trying to put away some sort of money each month to bring to court, even if it's only $100, so that you can put towards the restitution. If it's millions of dollars or even hundreds of thousands of dollars and you're driving around a Jaguar, a Maserati, get rid of it, get a Honda. The judge doesn't want to know, and they're going to know, that you're driving around an expensive car, but you want leniency. If you have multiple homes, start selling them. If there's the financial penalty, Congress and the Department of Justice and the Bureau of Prisons want you to offer, as soon as you meet you'll meet when you get into prison with your unit team or a case manager, they're going to want you to offer to participate in a financial responsibility program. So what that means is that there's something called the First Step Act, which hopefully you're aware of, but this allows you to take programs that allows you to earn credits, that these credits will allow you to get out of prison early. So a year's worth of credits will approximately equal 6 months of prison time where you can get out early. Approximate, not exact. At the same time, if you're taking in $1,000 or more a month, you may want to offer a couple $100 a month towards the financial responsibility program. If you're taking in a couple $100 a month, you may want to offer $25 a month, maybe $75 a quarter or something like that. But you have to offer something. If you refuse, then they may not offer you the ability to earn time, your earn time credits towards release. You don't want to spend time between a guilty verdict and sentencing doing nothing and being depressed and playing cards and watching TV. Get a job, volunteer, do something. But you can't be doing nothing. You also should spend time writing your narrative. Your narrative is your story. It's your autobiography. It's your history from childhood, your interaction with your family, siblings, through high school, elementary school, high school. Did you work through summers? Did you go to college? Not college. Your parents, were they home? What was the life like with the interaction between your parents, between your siblings and your parents after you left home, went to college, or went to work? And then how did you wind up getting in trouble? And this narrative a large part of it is, how did you wind up getting what caused you to get into trouble? How did that happen? And it has to include where you accept responsibility for your crime. You have remorse for what you've done, and you understand that you've caused pain to the victims that you have perpetrated. You understand that you have caused the pain to the victims for the crimes you've perpetrated. And all of this you can see through my website and my YouTubes for more information. You have also written a release plan. Why a release plan? Again, this information is on the website and YouTube's. But when you go into your sentencing hearing, one of the things the judge is going to ask you is that, what are you going to do when you're released? They don't want to see you back again. I learned that the hard way. And so you need to begin to have a release plan. And so believe me, even though it seems like a distant time, you need to begin to start working on a release plan. And the simplest way to write this is that, because you're going to have time, is that as you've been sitting since if you've been arrested, you were indicted, and you've had time to think, that you didn't realize, thought that you were as bad as what you've done was as bad as you didn't think it was as bad as really it is, and that you caused as much pain as you did. But now that you've had time to think about it, you've taken responsibility, and that you won't be doing this again, and you will definitely not be back in this courtroom at all. And you expand on that. And again, you can go to my website for more information, or YouTube's. I've mentioned, when you go into prison, you will be meeting with unit team and case managers, which have tremendous discretion over you. The First Step Back programs, you just don't automatically start taking programs. You need to take an assessment, a risk assessment. SMART 13 is what it's called, assessment. And there are questions. And so it seems to me that if you're able to see these questions before you get there, you can also weave these answers to these questions, where appropriate, either into your narrative or release plan. And so by doing that, you'll actually seem more prepared, both to your probation officer, to the judge, and to your case manager. And so all of this information now your lawyer is going to give to you, in addition to all the other information that your probation officer needs for your pre-sentence interview, several weeks before your pre-sentence interview. So all of that information now they can enter into their documentation, so that by the time you get to your interview, first, it's not going to be as long. Second of all, that the probation officer won't be under the gun as much, and they may actually appreciate having the time to casually enter this information at their leisure, more or less, and then have time to personally sit and have a conversation with you, which you'll get to give them time to know you on a more personal level. So I take all of this time to do all of this work, because they're stakeholders. And what are the stakeholders? Stakeholders are the persons that are responsible for your future. And who are they? Stakeholders are going to be the judge, the probation officer, the prosecutor, your attorney. It's going to be, once you get into prison, it's going to be the case manager, unit team. These people have tremendous discretion over your future. And so regarding your family, you and I, you probably, everyone believes you that you don't have to be in prison, but that doesn't matter. The stakeholders, they believe now you're guilty. You pled guilty, or you were convicted. And so now the stakeholders need to see that there's a reduction in your criminogenic needs, especially because you've taken, hopefully, the Spark 13 assessment. You've taken the First Step Back programming. And so now they need to see that your criminogenic needs or risk assessments, those criminogenic risks have been reduced, and they're seeing this incremental improvements over time. And that is a very big deal. And so the things that you're doing over time to help is you're now developing you're developing this incremental improvements over time. And I go through that more detail over the website, but you're basically documenting all of the programs that you're taking, so that you can show your case managers and unit team what you're learning. And surely there's going to be frustrations. There's going to be disappointments over, while you're in the Federal Bureau of Prisons. No doubt about it. We read about it all the time online, where the Federal Bureau of Prisons, they're having trouble calculating or earn time credits. But there will be staff that are going to be helpful, and there's going to be staff that are going to just give you a hard time. The only persons, though, that you can control is yourself. And so that you're just going to have to keep a positive outlook for yourself and try and ignore the staff that will give you a hard time. You have the Federal Bureau of Prisons as a new director. She didn't come up through the ranks of correction. She came through psychology. Your case managers can wind up being an advocate for you as long as you don't get infractions and you do everything according to First Step Back programs. You just do everything correctly as you mitigate your way to freedom. And I hope you found this helpful. If you want to enlist me to work with you to help you mitigate your sentence and engage in my services, I would be more than grateful to work with you. I thank you for taking the time out of your day to listen to this YouTube in its entirety. Give me a call and let's have a conversation. Again, have a good day and thank you for taking the time to listen.